Good morning, my ladies. Good morning, my lord. Just housekeeping appearances are the same, except for those people who were excused. Just a matter of housekeeping, my ladies and my lord, we will, well, firstly, we have had a discussion with our learned friends about time so that we can ensure that we finish. So we will not insist on taking a full day like they did. We will allow them, they've agreed that they will need about an hour. They'll need about an hour to reply on the basis that the amici don't have the right of reply. And so if I start at the end, we will endeavor to finish by 3 so that we allow them that space. It's, well, I'll be sure. I'm trying to explain that I'm going to be shorter than them. Yes, they took the whole day. Yes, but we want to accommodate, and in that time, my lord, particularly we might not be, if the court adopts the same attitude of not asking questions, and we might even be shorter. Yeah. But we're assuming that there'll be some engagement. But to come directly to what will happen next, as I indicated earlier, Mr. Masuku will go first for about an hour just to deal with amici, all the amici. Then I'll take it from there on the actual 2 cases as the court pleases.
Honorable Justices, we had considerable, wide-ranging and extraordinary submissions made by the amici, the media amici and Helen Suzman Foundation and the Democracy in Action. And it's important that we set out the context in which we make our submissions in response to their submissions. When we offered our consent to have the amici granted the status of a friend of the court, we were aware of these extraordinary, antagonistic attacks that the amici were taking against Mr. Zuma. But it was practical for us to grant them consent so that the court, in its exercise of discretion, may decide whether, in fact, they have submissions from a friend of the court. Having heard the submissions of amici, can this court say that it has friends in the media or friends in the submissions of the Helen Suzman Foundation? It is important to reflect on the role of amici because courts over and over again emphasize that the role of the amici is to assist the court in its adjudicative process. It is to assist the court reflect on the dispute and to come to what the court say is a fair and just conclusion. You recall, Honorable Justices, that courts sometimes invite amici because before it comes up a complex matter for which it's justified to invite an amici. So the purpose of the amici is to enrich the court's thinking of the issues and the dispute. In return for the privilege of participating in proceedings without having to qualify as a party to the dispute, an amici has a special duty to the court, and it is to provide helpful and cogent submissions that may assist the court in its reflection of the dispute. So it would be an error for the court to invite into its adjudicative process a party who masquerades as a friend of the court when in fact that party is an opponent of one party and is entirely antagonistic to the other. If the court were to admit submissions that assist a party before it, it would rightly be accused of lacking in independence, impartiality, and fairness. That is why in the Constitutional Court, in Ex parte Institute for Security Studies, in Re S versus Basson, 2006, Volume 6, SA 195, the Constitutional Court at paragraph 6 held that the footing on which the amicus is heard is that the person will make submissions on law and relevant facts which assist the court in a way in which the court would otherwise not have been assisted. So the main mission of the amici is to be a friend of an independent, impartial court exercising independence and impartiality on the issues, on the dispute before it. So a friend of the court must make submissions in a manner that reflects the neutrality and the independence of the court for whose benefit the amici has been admitted. To take an entirely antagonistic position, to berate one party, to attack the bona fides of one party by an amici is unseemly. It is not the role of the amici to attack one litigant under the cloak of being a friend of the court. So the amici must make submissions that are relevant to the issues before the court. Those submissions must be useful to the court. Those submissions must be different to those of the main parties to the case. But as Museneke in the case I just referred to said, former DCJ Museneke said in the case I just referred to, he said that an amicus may advocate for a particular outcome in a case, but when they do so only for the benefit of the court, and they do it exhibiting the neutrality and the independence that a court is expected to when they exercise, when they assess the submissions of the amici. So the fact that amici has been admitted by consent does not absolve this court from carefully determining whether they have friends who have been admitted to assist the court's independent and impartial adjudication of the matter, and not merely added opponents against one party. I emphasize that it would be inimical to the true attributes and nature of the court to admit a person, an amici, as his friend, who is an opponent of a party seeking justice before that court. Against those brief submissions, we contend that the admission of these amici into these proceedings does not absolve the court from determining whether they are indeed its friends, whether they are indeed friends of the court, and not merely opponents of Mr. Zuma, who are here to load it against Mr. Zuma, who are here to add more condemnation on Mr. Zuma's private prosecution. You would have heard amicus even choice of language in attacking Mr. Zuma. We submit, Honorable Justices, that the media amici and the Helen Suzman Foundation have spectacularly failed to utilize their status as a friend of the court to make submissions that are helpful to the court, that would enhance its adjudicative view, its adjudicative process, or even enhance its independence. The perception that the court must be independent is very important. And when it has friends assisting it who are antagonistic to one party, the court ought to be careful how they receive those particular submissions. You would have seen that the Helen Suzman Foundation goes as far as falsely alleging that the private prosecution of a prosecutor is an attack on the entirety of the NPA. That's an extraordinary, they in fact go as far as saying that the private prosecution is an attack on our constitutional system. That's entirely unfair. It's not founded on fact. It is not the role of an amici to come to court to condemn a party who is exercising what is recognized in law as a right of a party to have a dispute resolved by an independent court. A court must not have no such friends. These ad hominem attacks on Mr. Zuma cannot be met by a court or even condoned by a court, because the insults heaped on Mr. Zuma cannot truly reflect the dignity of the court or enhance its independent and impartial evaluation of the main dispute. So it's common. Everybody knows that an amici, as a friend of the court, is not admitted to bolster the case of one party against the other, because a court may not have such a friend. So a court would be acting contrary to its nature and constitutional mission if it accepts the submissions of a party that does not reflect in its submissions an independent and impartial evaluation of the facts and the law that is relevant to the dispute for which must be adjudicated by the court. I refer again to what Justice Museneke Deputy Chief Justice Museneke, as he then was, who concluded that the amici may urge a court to reach a particular outcome. Here is the qualifier. And he says, but it may do so only in the course of assisting a court to arrive at a just outcome, and not to serve or bolster a sectarian and partisan interest against one of the parties in the litigation. Let me begin. I will, in the course of making my submissions, I will quote from. I will reflect on the insults. I believe are insults that should never be made by a friend of the court. But let me begin by what the amici do not make submissions on, in order to provide the context of why we respond the way we do to their submissions. The amici do not allege that the crime in Section 41(6) of the National Prosecuting Act does not exist. So they're not here in court saying, no, that crime does not exist. They know the crime exists. They would be hard-pressed to resist the tried proposition that where a person, whether it is a journalist or a prosecutor, without permission of the National Director of Public Prosecution, or a person authorized to disclose information within the NPA, that person would be let me restate again. So they would be hard pressed to resist the proposition that where a person, whether is a journalist or a prosecutor, without the permission of the NDPP, or a person authorized in writing by the NPP discloses to another any information which came to his or her knowledge in the performance of his or her functions in terms of this act, which is the NPA Act, or any other law, the contents of any book or document or any other item in the possession of the NPA, or the record of any evidence given at an investigation, shall be guilty of an offense. Section 41(6) does not discriminate. Doesn't say that if you are, it uses the word anyone. It doesn't say that there's a special place for journalists, and this will come to how we deal with their contention on Section 16, where the contention is that Section 16 is Section 41(6) must be read in such a way as to preserve the right under Section 16. Let me make this point right up front. Section 41(6) does not prohibit disclosure of information per se. It prohibits disclosure of information without the permission of the National Director of Public Prosecution or his or her authorized individual. That's what it criminalizes. The defense of Mr. Downer, defense of Ms. Maughan, could have simply been, we have this information from the NPA, we've got, here is the permission we got from the NTPP. That would end the case against them. So, to suggest that there is an attack on Section 16 is a misreading of the law. Now, Mr. Mpofu will deal with the formal, whether Mr. Zuma has complied with the formal legal requirements for bringing a private prosecution against Mr. Downer and Ms. Maughan. But for purposes of my argument, I'll assume he has. What appears to ache the amicis on which they peg their submissions is his state of mind when he triggered the process of private prosecution. They want to suggest that he had an ulterior motive. He said somewhere in Kanda and cooked up a scam or a prosecution scam or what they call a sham, and they call it a game. The Helen Suzman Foundation prosecution. They call this a game. Mr. Zuma has a game to play. He sat at Nkandla. Former President Zuma sat at Nkandla somewhere and cooked up and manufactured a prosecution scam, prosecution sham, in order to avoid accountability, in order to avoid, or in order to play political games, as they put it. That's an extraordinary statement coming from a party who is supposed to be a neutral and independent party. So it does appear to us that amici do not contend that Mr. Zuma has not complied with the formal legal requirements. Over and above those formal legal requirements, they contend that you ought to look at his motive. And if you should come to the conclusion that he has ulterior motives, what you need to do is to then dismiss this application, interdict set aside the summons and stop the prosecution altogether. The Helen Suzman Foundation goes as far as contending that even if this court were to hold that there is a prima facie case for a prosecution under Section 41(6) of the NPA Act, Mr. Zuma's alleged ulterior motives or ulterior purpose for bringing the prosecution vitiates the lawfulness of the prosecution. In other words, they say even if you were to come to the conclusion that prima facie there's been a violation of Section 41(6), look at Mr. Zuma's conduct. On his own conduct, they say read in ulterior motive, find ulterior motive. And when you do find the ulterior motive, set aside the summons and stop the prosecution. What they have done over and above the legal requirements for bringing a prosecution, is to impose ulterior motive as a jurisdictional requirement for bringing a private prosecution. They are essentially suggesting that ulterior motive can vitiate a lawful prosecution, because the submissions made by Helen Suzman Foundation is that even if you are convinced that there is a prima facie case that a prosecutor of the experience that Mr. Downer has violated Section 41(6) in that he has unlawfully disclosed documents which are in his possession, which are obtained by him by virtue of that position he has. He has disclosed to a journalist. Even if you were to find that that is the case, if you should find that Mr. Zuma has ulterior motives for prosecuting Mr. Downer for that offense which is set out in 41(6), you must then set aside the prosecution. We can assure this court that Mr. Zuma has tried many times, that Mr. Downer, in many instances, points it out. Whenever he has an opportunity to point it out, he points it out. That Mr. Zuma seeks to perpetuate a political conspiracy against him in this prosecution. Of course, it doesn't refer to the only evidence of the National Prosecution Authority by Willy Hofmeyr, where it's clear that the NPA in relation to the criminal prosecution of Mr. Zuma is a crime scene. And Mr. Downer, from the beginning to the end, has been a prosecutor while the crimes were being committed within the NPA. So the amici is here in a very partisan manner, very antagonistic manner, to bolster the case. In the case of the media amici, you will have noticed that they have issued, Mr. Mpofu will deal with that, but they have issued media statements, making it unequivocally clear that they are here supporting Ms. Maughan. The media is here supporting Ms. Maughan. So what they have done in order to support Ms. Maughan is to create factual basis for it, which is not borne out by the facts. They've created a factual basis, one of which is that Mr. Zuma is here prosecuting Ms. Maughan, a seasoned journalist, for ulterior motives and to silence her. You'll be glad to hear that even yesterday when we were here, Ms. Maughan was busy on News 24 sending out information. In fact, what I'm saying right now is probably going to be in the news today. There is no evidence whatsoever of any threat to Ms. Maughan as a journalist. No single piece of evidence. The only evidence they try to hang on is the evidence that comes out from social media, of which Ms. Maughan injected herself into. On her own, she goes into social media. And a friend and colleague of mine said social media is an ungovernable space. It's cruel in social media. So when she gets what she gives, she then complains that Mr. Zuma is responsible for it. That's manufacturing facts on why this prosecution is here. The prosecution is not a prosecution of Section 16 constitutional right. It is not. It's false to suggest that somehow this private prosecution must be seen as an attack on the media. There is not a single litigant in this country. And one of my respected senior counsel said yesterday that Mr. Zuma has brought so many applications for over a period of 20 years. So he's familiar with the court process. Right? He is one of the most reported litigants in this country. And the media has not been very kind to Mr. Zuma. But because he fought for them so that they could have this freedom to report on whatever they want to report, he walks away. He laughs sometimes. He takes it by the chin. And life goes on. But you breach a law, Section 41(6), as a journalist. You try and hide on manufactured facts, and you try and hide behind Section 16. That's an irresponsible response to a Section 41(6) charge. It's a false response. It's not born out of facts. It's not born out of evidence. This is not a case in which a private prosecution is attacking the media or is attacking Ms. Maughan. Ms. Maughan is caught in the factual narrative of the facts which Mr. Mpofu will deal with. If you confine this story to the facts, you will not see the relevance of Section 16, because this had nothing to do with Section 16. So when they say as a media, that the prosecution or that the private prosecution is aimed at using, I beg your pardon.
I'm hearing some strange sound emanating from my lord. Someone got a cell phone on something. It's like music or something. Please, I'm going to ask you for the last time to ensure that your cell phone was switched off.
No, it's so the interest of the media in this, the media are making in this application is entirely partisan, entirely antagonistic of Mr. Zuma. They essentially caricature, they seek to devalue the dignity of Mr. Zuma by suggesting that he is an enemy of the media. So they are here saying protect media freedom on manufactured facts. The true facts of how Ms. Maughan came to become an accused person in the private prosecution have nothing to do with how she reported in any of the reports. Nothing to do with it. So it's not true that this private prosecution is by a person with power who seeks to stifle dissent and criticism. It's not true that this case of the private prosecution is an example of how the law, including our courts, can be rendered at risk of being used as a tool by persons with power to stifle dissent and criticism. At the risk of repeating this, there is not a sink of evidence, not an iota of evidence that this private prosecution has affected the media, its ability to report, or even its safety. There's not a single point of evidence that the media amici could give which support their contention. I mean, they give us obviously reports, but those reports don't reflect South African reality. Many South Africans would not quibble with the proposition which the media amici makes, that courts can be used by a powerful person in society to stifle dissent and criticism. We are all too aware of how courts were used by the apartheid government to stifle dissent, to stifle criticism. Mr. Zuma was a victim of that. Mr. Zuma went to jail because of the system of law and courts that were used by the apartheid system and its machinery in order to stifle dissent. They basically don't want him to speak and to disagree with the system of apartheid. So we're familiar with that principle. But it is absolutely an irresponsible accusation to suggest that Mr. Zuma has triggered this private prosecution because he wishes to stifle dissent, when there is absolutely no evidence of that. The evidence of the apartheid system is there. Mr. Zuma is the evidence. He was in jail for 10 years because he had something to say about the apartheid system, which the apartheid government didn't like. So they arrested him and they put him in jail. Well, I don't want to say what happens after independence or after the constitutional democracy, but he's been to jail again during the period of this constitutional democracy. Let me deal with the slap defense or the slap plea. The media are making, that's a refreshing sort of argument they seek to present. So to their credit, would accept that that's the idea of trying to extend the slap theory or the slap doctrine to cover criminal cases is a novel one. How it works, we don't know. What its attributes are, we don't know. They have not told us. But here is the problem. The SLAP means strategic lawsuits against public participation. Strategic lawsuits against public participation. It's not very clear how this private prosecution should be regarded as a SLAP suit. It's not clear on what legal principles, other than the already existing one, which is the doctrine of abuse of process, that the SLAP doctrine will assist the courts. But let me immediately deal with that, because even if we were to say, for good measure, do extend the SLAP doctrine to cover criminal prosecutions. Firstly, remember that their motivation is obviously mercenary, in the sense that their main target is Mr. Zuma. But let's accept that in terms of how we do our criminal cases. This SLAP dispute both that the defamation suit brought by the plaintiffs is an abuse of process of court, that the defamation suit brought by the plaintiffs is an abuse of process of court, to achieve an improper end the the state will have to wait until the component of that theory would be in a criminal prosecution. There is no case in South Africa that we are aware of, a criminal case that we are aware of, where the slap defense was raised. And it's so even the motivation for the introduction of the slap defense, it's false. There's no evidence whatsoever. You heard from the media amici that there is a growing trend of attacks on journalists for doing their work to justify the employment of the slap doctrine. A growing employment of the slap doctrine. A growing trend against journalists. In South Africa, we don't have a single criminal prosecution in which the prosecution had to deal with the slap defense. So it's not clear why these facts are here, because there is no evidence whatsoever. They can get evidence elsewhere, but the evidence relevant is evidence here in South Africa. And so we say that it's wrong for the media to suggest that there is a growing attack on them, and the available defenses to them are not good enough to stop these attacks. That you would need to have a slap plea in order to get your way to defend yourself against a prosecution. Let me. So we would say that the extension of the slap doctrine into criminal law would certainly be novel, but it certainly will not make it easier for both private and public prosecutors to conduct their criminal prosecutions in the manner in which the Criminal Procedure Act says they should. So the supporting facts there is that there is a growing trend of attacks on journalists. The evidence in this court is that a single journalist faces private prosecution. Through the window of that single journalist, they want you to introduce a plea in the criminal process that will basically introduce a new terrain for criminal prosecutors. There is no factual justification for it, but even if you were to find that it's an attractive doctrine to extend to criminal proceedings, we say you mind the difficulties that you are making for the criminal prosecutors, public criminal prosecutors, and for the state and the individual or private citizens who wish to prosecute. Then there is a theme that runs through both Helen Suzman Foundation and the media amici. I've dealt with the media amici. They have no evidence whatsoever to suggest that Mr. Zuma said somewhere and manufactures this private prosecution in order to stifle dissent or to stop Ms. Maughan from being the exceptional reporter that she is of the private prosecution. Extract from that conduct whatever you can extract, and infer, you will find a good inference, an inescapable inference, that this prosecution has not been activated against Mr. Downer and Ms. Maughan for legitimate prosecutorial reasons, legitimate purposes. But it is, in Helen Suzman's extraordinary attacks on Mr. Zuma, it is to pursue a political agenda. They don't say what that political agenda is, by the way. They just throw politics in it. They just throw insults and epithets that are very unkind to Mr. Zuma, but not true, not supported by evidence. So the notion that a private prosecution of a crime that exists on the facts that we have can reasonably lead to the conclusion of ulterior motives absurd. It's completely absurd. But it's consistent with their position that Mr. Zuma is after the constitutional system, prosecuting one prosecutor for a crime that exists. Honorable Court, let me just deal with the submissions made on Section 41(6) and how the interpretation of that provision should be approached. Clearly, the attempt of the media is to interpret Section 41(6) in a manner of the NPA is to ensure the integrity of the prosecutors of the office of the National Director of Public Prosecution, of the National Prosecuting Authority, to ensure that the information they have, on which they rely to conduct their work, does not lead to the prejudice of people that are implicated in that information. So it's a valid purpose. No one can quibble with the purpose for saying to prosecutors, information you get while you're performing your functions must be held in strictest of confidence. The media amici says, if the law is interpreted as we believe it should be, that would not protect journalists from the reach. That would not protect journalists from criminal prosecution for violating the law. But I've already, relying on the principles of Ndomeni, the famous case on statutory interpretation, it's clear that the interpretation they seek to advance is untenable. Interpreting a law in a manner that would essentially discriminate people would be wrong. It would discriminate them on the basis of calling or profession or whatever whatever else is. But here is another false submission or inaccurate submission. It is that Section 41(6) implicates the right of free speech in Section 16 of the Constitution. I've already mentioned that Section 41(6) does no such thing. Section 141(6) prohibits the disclosure of information without authorization. So it does not per se prohibit disclosure of information. You must just get the permission from the National Director of Public Prosecution or the assigned, the delegated functionary by that office. The media amici do not tell us that it is difficult to get that permission, or getting that permission would impose an unconstitutional barrier on the freedom to report on information that they get. They don't tell us those kind of nuances. So the 41(6) argument falls away. It has nothing to do with Section 16 because it does not prohibit the freedom of speech, or the freedoms under Section 16. It merely says to journalists who want to report on information obtained by the information obtained from the NPA, please get the permission of the National Director of Public Prosecution before you can publish this information. Once you get that, that's where your protection is. We sort of reserved fairly harsh terms for Helen Suzman Foundation for a good reason. And it is no exaggeration that their submissions, their conduct as amici essentially is an abuse of the status of friends of the court. This is one case where words are just used carelessly without any thinking, but you can see that perhaps I'm guilty of that myself, but mercifully, I can quote from what they say in their founding affidavit. I'd invite the court to look at the founding affidavit, to look at what they say about Mr. Zuma and the private prosecution. They say that Mr. Zuma's prosecution of Mr. Downer is an explicit attempt to undermine the criminal justice system. I beg your pardon? The affidavit of Ms. Fritz of the Helen Suzman Foundation. They say it's an explicit. No, they don't even say it's implicit or something softer than anything. They say this is the clearest attempt to undermine criminal justice system. That's sedition. That's serious stuff. For someone who has served time in jail for contempt of court to be accused of undermining criminal justice, this is propaganda. This is not responsible exercise of a friend of the court, and the court should dissociate itself from such a friend. They say that he does not come to this court seeking adjudicative determination of the so-called criminality of Mr. Downer's conduct. They say he comes to court in bad faith and for an ulterior motive to pursue political ends and accountability, none of which is supported by evidence. There is no evidence of what these political ends are. What is the accountability he is seeking to avoid? So here is the problem. By an organization that stands for human rights, making these kind of arguments. Mr. Zuma is being prosecuted. Mr. Zuma's prosecution by the state is conducted by Mr. Downer. What Helen Suzman Foundation says is that if a prosecutor commits a crime in the course of conducting a prosecution of an accused, the accused has no remedy. But if the accused person should seek to prosecute the prosecutor for committing a crime, that is an ulterior purpose, a bad faith, and it's an attempt to avoid accountability and to dabble in politics. Mr. Zuma has no political interest in pursuing Mr. Downer, except that Mr. Downer, in the course of conducting his work as a prosecutor for the state, did some things that Mr. Zuma believes violate the law. Here is another false statement by the Helen Suzman Foundation. They say Mr. Zuma takes aim at the NPA itself. That's false. Prosecuting Mr. Downer is not taking aim at the National Prosecuting Authority. It's inflammatory, it's not borne by evidence, it's simply an irresponsible statement that is conjured up by somebody who, an entity that comes to court pretending to be a friend of the court, when in fact it's an enemy of one of the parties. I've already said that they consider Mr. Zuma's prosecution as a game, and they say he intends to pursue a sham. You can't have friends like those, honorable justices. You cannot have a friend who speaks like this about a party who seeks justice for you. It's wrong. They should come out clearly and say who they support, which they do, by the way. But then they seek the gaps of a friend of the court to make these kind of inflammatory statements, which are not born out of the facts. What the Helen Suzman Foundation does not do is to take the entire factual matrix. They say They say in fact, if this process, it would be debated. That Mr. Zuma seeks to avoid in a system governed by the rule of law. Rule of law includes private prosecution. So Mr. Zuma is sliding bang right there in the middle of the rule of law doctrine. They forget very obvious facts which should not be easy for an organization of the nature that we are dealing with. Obvious facts. If you look at the 19 years that they accuse Mr. Zuma of playing dilatory tactics, former public protector Mshwana said the NPA had acted significant standing. His views matter. In gaps of a friend, but in fact seek to poison the atmosphere of fairness. Seek to look against Mr. Zuma. So simply put, the Helen Suzman Foundation appeared to be an additional advocate for Mr. Downer. The extensive narrative propagated by the NPA that Mr. Zuma seeks to escape justice by adopting as Mr. Badlander says, meritless applications. it's a cause for concern for an organization of this nature that says we're a human rights organization to not be concerned about what they discovered when they investigated what had happened in the prosecution of Mr. Zuma by an entity with so much power. So, the media I'm making with is the allegation by Helen Suzman. It's quite clear there is no basis, no factual basis on which the Helen Suzman Foundation can support this extraordinary, very vague, unsupported. What is extraordinary? Not are not only unfair.